how is process to make law in Sweden and who has the authority?
Yes, actually, you are totally right. That's the basic problem relationship between law and politics. That the politicians want to use the law to gain their certain results. But as you said, there is a structure of law. There is a legal culture that stop. Sometimes they say politician, no, you cannot do this because it will somehow disrupt the entire structure or the entire systematic.
Oke, assalamualaikum warahmatullahi wabarakatuh. Salam perennial. Kembali lagi kita bersama pada hari ini di channel Perennial Law. Hari ini adalah hari yang sangat istimewa. Today is very special for us because our guest today, special guest. I think this is the first one from other country, Mr. Moro. Thank you, Mr. Moro.
Thank you for having me here. It's an honor.
Thank you. I will try to speak in English. I hope Mr. Moro can understand what I mean when I give some question. Thank you. Before we continue, I will give information about Mr. Professor Mauro Zamboni. Mr. Professor from Stockholm University, and Mr. Professor special in Professor in Jurisprudence at the Department of Law. That's right, Mr.
Yes, exactly.
And the next researcher at Stockholm Center for Commercial Law and Director of the Global Legal Research and Information Management Winter School, and intense study program organized under the roof of the European Academy of Legal Theory (ELT), and general editor of the journal The Theory and Practice of Legislation. Thank you for Mr. Professor to come to small studio in here. I will give information for Mr. Professor, Mr. Moro, and that our channel try to give some education or inspiration about law to our young generation in Indonesia. I hope for our conversation today will give inspiration or motivation to our young generation how the law student take his study in Sweden, and maybe there are some a good information for us. We must know about the how to study in Sweden. Thank you, Mr. Professor. There are some books, Mr. Professor, too. Law Without State. I think this is very interesting. The title, Law Without State.
Yes.
Maybe later we can understand about that. And Making Evolution Theory Useful for Legal Actors, 2011, and Legal Pluralism World, and Law and Politics. Okay, Mr. Professor.
Yes.
For the first, maybe we can know about Mr. Mauro. Why you choose major law when you study in university?
Well, actually, yes, that's a very good question. Actually, there is two folds of answers, and the first one that I always like politics.
Oh, politics.
Politics, actually. But since I'm coming from a working class family, to study political science, it would have led me probably to be unemployed. So I tried law. I did law because it was the closer to politics, and that you had a kind of guarantee that you will get a job afterwards. So I try to combine both my more ideal part, that is that I like very much study of politics, with the fact that since I'm coming from a working class family, My parents put quite an effort, economic effort, to make me go to university. So I needed to have a topic that would give me a job afterwards, and that's why I chose.
But basically, Mr. Professor like to knowledge of politics.
Yes. I could have done also to get a job. You could have done, for example, medicine or engineering, but I was not interested. I was interested in politics, and I think I made the right choice because law and politics they really go hand in hand. So that's why I like it very much.
And when we are talking about politics and law, I think that's a have relation between law and politics. And the next, Mr. When you see from, I think you have many experience when you study in university. What's the big problem when we are study about law? What's your experience when you still study in university? What's the big problem?
You mean for us as a teacher, or for the students?
For the student.
For the students, that's. I think the biggest problem. I think I've seen in Sweden. We can see two types of problems. The first one is that. Sometimes you get the feeling that people has chosen law, but they are not really interested into law.
This is the first problem.
Yes, I would say so. It's the first problem that people have chosen law because maybe pushed by the parents or because of job, because it's a classical profession. It's like medicine, but really they don't have passion. I see compared maybe with people studying philosophy or mathematics, which are truly interested in the topic. That's I would say this. And the second major problem, maybe I would say the biggest problem, at least at the law faculty in Stockholm, is the level of stress for the students.
Stress?
Yes, they are very much stressed because then there is competition on the market when you're finished, so you have to have a high grade. And so it's kind of also internal competition among the students who get the highest grade because they are under the impression that if you get low grades you will fail in a career, which is not true, or if you get average grades. So there is a high level of stress among our students, something that we are well aware of, that we are trying to push it down this level, but still I would say this is also is a major problem among the students. So.
I think just the same in Indonesia, Mr. Because there are some students too, they choose faculty of law because from the parents, suggestion from the parents, and they don't have interest about that.
Exactly.
And this, we must understand about this, about stress. This is stress, the student stress when he study or after they graduate from
I would say after when they study.
When they study.
Yes, also because you have to understand they are very young, they are inexperienced. If they were 30, 40 years old, they have kind of experience, they know that the grades are not everything and so on. But since they are young and unexperienced, they think that the grades will determine if they get an average grade, they will they will have an average life, which is totally not true. But so we get this kind of they get this kind of stress.
This is I will try to ask Mr. Professor. Is there a subject in faculty difficult to understand from the student? Is there one according to Mr.?
Yes, actually we call we have a 4 years program because it's both bachelor and master, and we say statistically there are what is called two walls. It means where it's very difficult to get over it, which is it's because it's difficult. And the first one I would say is general contract law.
General contract law.
Yes, which is in the second year, and in the third year, I think fourth year is administrative law.
Administrative law.
Yes, that's I would say these are considered the two. We call them the walls. That then they can stop a bit the students. Then of course every student has their own it depends very much. It's very subjective what is difficult. For many, contract law is easy. Maybe my topic, legal theory, is difficult. For other, legal theory is easy. So it's very much subject. But generally speaking, I would say it is contract law and administrative law. Yes, okay. They are very, very heavy. I think it's called the wall also because they are very heavy. It's like 15, 16 weeks just doing this. So
just to understand about that.
Yeah, just for the entire course is 15 weeks, and you take just this course. So it's quite intense. Yes.
Okay. Thank you, Mr. And the next Mr. I think Mr. Mauro have many experience too when as a lecturer. Now we're talking about when Mr. as a student. Now we talking about when Mr. Professor as a lecturer.
Yes, when I teach. Yes.
And what is the problem, Mr. Professor, when you are teach student in Sweden?
They are passive, extremely passive. That is, you cannot have a conversation with them. It's always, it's always a monologue on my side. It's very difficult. Also, it is two factors that play in. First, in particular, when we have big lectures, it's like you have 200, 250 people in one room.
And so much people.
Yes, and so, it's very difficult to have a dialogue with the students. Plus, there is also a bit of Swedish attitude. The character is quite shy. You do not talk. So they tend to be. That's, I would say, is the major problem to be. Is the passivity that is often when I have lectures, not only me, also my colleagues. When we have lecture, it's very difficult to start a conversation with them, in particular in the big classrooms.
So, what's your solution?
Yes, actually, we found a quite good solution. That is. First, when it comes to big lectures, we register them. That is, they do not come on campus. We register them in some rooms, and then we have them on the web. So because there is no interaction anyway with the students. So we have pre-recorded lectures which are available for the students on the web that we register in a studio like this, more or less. That's the first solution. The first step for the big lecture. For the small lectures, in order to activate the students, what we use, we usually give assignments. And then it is not much of a lecture. That is, most of the time they have assignment, they have to discuss each other, and they got grades for that. So often, let's say, we give them an hypothetical case, and then we divide in three groups. You represent, you represent the defense, you judge, and you represent the other parts. The general attorney. So that's a good way is to directly activate the students, and we get very good results. But instead of sitting there, me lecturing them, is most that they read at home. They have to do, and they prepare often in groups, and then they come and they hold somehow the lecture.
They must presentation.
They have to present, and then the other part has to discuss them, and they have to defend themselves. It's also good training, for them to present things and to defend their positions. Okay, that's
when Mr. Mauro do like that. Are the student have interest to discussion to the other?
Very much. I tried this solution also when in 2019 I was in China, for example. I did this also formula, and it was very good. It was a very good experience for me, but also for the student, but also for me. It is very good to activate. It's called activate the students, with self-reflection and so on. Instead of having the traditional, I'm the teacher, you're the students, I talk, you listen. In particular for the students in my years, because I'm in the last years, then maybe you cannot do it in the first years because they are quite inexperienced. But when it comes this third, fourth year, there are also many colleagues that use this seminar. We call them seminars, where the students are activated. You give fictitious case, fictitious law, or real case or real law. and you let them discuss about it. Of course, and you have this leading role that to point the discussion in the right direction or correct them when maybe they say something which is not totally true, and so on. But it's more. It's a question to give also to the students self-confidence. Self-confidence.
Yes, they must self-confidence.
Yes, and they are usually
to give self-confidence. Yes. Before that, they must to study first.
Yes, of course. That's the point. When you are at home, you have to read the books. You have to read the books, then prepare the case, and so on. And then you come in the classroom to discuss it. Yes, exactly.
When they understand about the subject, I think they have capability and they have motivation to give presentation.
Yes, exactly. And of course, if something they have misunderstood, did not understand, it comes during the discussion, and then explain, look, maybe it's not like this, it's like that, but it's a good way that they start first the work. Exactly.
Okay, thank you, Mr. And the next, maybe we can, Mr. Professor, to explain to us how the law in Sweden works.
It's a civil law country.
Civil law country.
Yes, so legislation play a dominant role, but it's a particular, it's not real civil law actually, as I was explaining to my Indonesian colleagues. Usually in comparative law they talk about Nordic European family law, North European kind of law, where you have not family law in the sense law of the family, it's meant as a group, and it means that simply it is civil law that is legislation, is the central one, but also the judges and the public administration play a quite relevant role for the interpretation and the application. So I think it is quite similar as a system, more or less, also as here in Indonesia. Also here you have a civil law. Civil law system. So
but in Indonesia, still understand about culture. How about in Sweden?
The culture, well, of course, Sweden is not as multi-ethnic and multicultural as Indonesia. It's traditionally has been always a very homogeneous country. Yes, quite homogeneous country. That is one religion, one ethnic group, one language. Something has changed in the last decades, due in particular to migration. We got many migrants, but still it's like this, that there is a kind of unity in culture, language, and so it's not. It's very unified somehow country, homogeneous country. I will say so. In this sense, but I was making comparison with Indonesia with the idea of what is. Usually when you talk about the sources of law, the most important is the statutory law. That is the law written by the parliament, which is then interpreted by the judges, applied by the public agencies, and so on. So it's quite traditional in this sense.
Positive law.
Yes, exactly. It's positive law is it dominates everything in Sweden, much more than definitely much more than Indonesia. Positive law is when you talk about actually often the students confuse the terminology. We have they use the same word statutory law for law. So for in Sweden is really identified the two. Like in many countries in Europe is like this. You identify positive law with the only law. Yes.
Most of country in Europe like that, Mr.
Sorry, excuse me.
I think most of country in Europe, like in Sweden.
Yes, exactly. As I told you, you tend to identify positive. When you talk about law, you mean positive law.
Okay. Next, about how is process to make law in Sweden and who has the authority?
Actually, it's quite particular. It's very long in Sweden. It takes usually takes a couple of years, and it is simply. And what is strange is very much dominated by the we will say by the experts, actually, not by the politicians.
Oh, not just the politicians.
No, because it happens like this. I'm simplifying it very much, but it happens like this. Politicians give the task to write a law, to, for example, to an old judge, usually to some lawyer working an expert lawyer working in public agency, in the public administrations, or to law professors. And they are they that write the law. It's not the politicians, also because the politician cannot write the law. I mean, they lack the knowledge. So actually the law is very much written by experts.
Like
Professors
lawyers.
or for example, someone who has worked as for 40 years in a public agency, in a public administration, as a legal expert, and then or old professor. They write the law.
After that?
After that, what they do is that's compulsory, is written in the Constitution. They have to send the proposal of the law to all the interest party, the draft, the preliminary draft, so that the interest party can, for example, if I write a law about companies, I have to send the draft to the Association of the Swedish Companies, to the trade unions.
Give public maybe, yeah.
Yes, also the public, so you get the others' opinions. So what do you think about this new law? And they always send, all the laws are sent to the faculties of law, for getting our opinions.
To discuss maybe.
To discuss. After that, they often rewrite the law, they adjust it, and then it is sent through the government, it's sent to the parliament for the decision, and usually then it is approved by the parliament. So it takes 2 or 3 years, but usually the quality is very good. Also because it's often not political law, it's not made by politicians, it's made by experts, actually. It's made by experts.
Okay. But the last in
The parliament.
In the parliament.
Yes, they decide, but they never change anything. They never change. No, they never change anything. Usually they.
This is the regulation like that.
Well, no, you can change. You can, of course. You have, as a parliament, you are the ultimate sovereign. You can do whatever you want. But it has been a constitutional praxis that either they approve the law or they refuse the law. They then tend not to change it. So that's,
may not to change. Yeah.
no, because they are not experts, and moreover, the government usually has also the majority in the parliament. So the government, once, because after the draft is completely sent to the government, if this government decide to send it to the parliament, then the parliament will follow the government, because usually the government is an expression of the majority of the parliament.
Parliament just to sign some of the.
Yes, more or less is like this. Yes, more or less is like this.
Maybe this about just the same from the first question just now. How the government in Sweden guaranteed to the people that the law was made for the people, not for just what politicians want.
Well, actually, there is a very good tool. After 4 years, there is an election. I mean, it's pretty easy, because if you do not... actually, in this, I must confess, Swedish politicians are very good in doing what they promised during the electoral campaign. They tend to do it. Because they know if you don't do it, after 4 years, the people will vote another party.
Like that.
It's very easy. I mean, I think often you forget that in a democracy, the people has an extraordinary tool that after 4 years you can send the parliament home, or the party home. I mean, if you are satisfied. So I think I think the government is well aware of it. They are very sensitive about the electorate. And so they tend to do what they promise to do, because they know if you don't do it after 4 years, when there is the electoral campaign, you'll be you'll be considered accountable for that. You promised this and that, but you did not deliver, and the people is not stupid. So if you do not deliver, then we will vote another party.
I think the people must understand about who is they can choose in the election.
Exactly.
Okay, the next, Mr. We are interested to know about your book, Law Without State. What do you mean about that?
Yes, actually, it's not my book. It's a book which I participated. Yes, with a chapter. For a period, I researched quite a lot about this. The fact that, especially, particularly in modern time, you can see there are other normative systems than the law actually, which I was focusing, that was mostly my postdoc, when I did my postdoc in Germany, I was focusing, for example, on transnational corporate law, where most of the regulation is not made by the state, is made by companies, large companies, their agreements, NGOs also.
But the basic of their law from the state,
Well, actually, is
grander maybe.
yes, it's very difficult to say because, for example, there is large companies that operates abroad. They use their own. That's kind of agreements that they have, whether we have with other companies or with trade unions or with NGOs. Simply with law without a state, we evaluate the possibilities of having a law where positive law, the law of the states, is not the law, but is one of the many laws available, and that's quite common. I mean, it's called also legal pluralism, that you have different legal system competing with each other, where there is always state law, and state law is important, but it's no longer does no longer have the monopoly over everything. That's what we were talking about. For example, also the other day here about cultural normative systems, religious normative systems, social normative systems that play quite an important role today.
Okay, and this is a problem too when we are see how the law what's that we can say the practice of law in social.
Exactly.
This is there are two very important to apply the law. The first is the politician,
Yes.
and the next is structure of law.
Yes.
This is maybe in the, when we are see in the practice there is problem how to can give balances with what's the structure of law
Yes.
and politician.
Yes. That's a $1 million question. Yes, actually, you are totally right. That's the basic problem relationship between law and politics. That the politicians want to use the law to gain their certain results. But as you say, there is a structure of law. There is a
Yes.
legal culture that stop. Sometimes they say politician, no, you cannot do this because it will somehow disrupt the entire structure or the entire systematic. I think you are totally right in this. This is a general problem, particularly in all democratic countries, where you have politicians that they are representative of the people. They say, okay, we can do whatever we want, but there is on the other side, so the law has to adapt to our needs. But on the other side, there is, as you said, there is the structure of the law. There is certain principles like coherence, the principle of coherence, of consistency, or some basic dogmas, like for example, basic rights, that says that lawyers say, look, politician, you cannot do whatever you want.
Yeah.
There is certain limits. Otherwise, we don't have law. We have chaos, or we have anarchy. We have something else. So you are pointing out exactly this. It's very difficult to balance. It's a constant tension between politicians and structure of the law, or we can say the legal culture. There is a constant tension, and I think it's typical of every democracy. You can see.
This is difficult according to Mr.
Yes, it's very difficult to balance. It's very difficult to balance because on one side the politicians are correct in the sense they're representative of the people.
Yeah, yes.
While lawyer, we do not represent the people. We are
Yeah.
an elite. So on the other side, we have seen in history politicians, even if they represent the people, maybe they use the law to oppress the minorities. You
Yes.
know? That's why, for example, it's good to have a strong legal structure because they say whatever the majority is in the parliament, there are certain rights that you cannot touch upon. Right of minorities, or minorities also political or social, or religious, or ethnic minorities, for example. So it's very difficult because both have good points. So it's a constant balance. But I think this is also it's kind of the human nature. Is you never find a perfect solution. You try to balance two solutions.
So when there is a problem maybe about that, which one we must believe, that the politician or structure of law?
you have to believe yourself. I mean, law is not a religion. You don't have to believe. And neither law is a religion nor the politician are a religion. You have to trust for yourself and to trust the facts. Because as I said, sometimes to have a strong legal culture is good because it stops politicians. Other times they are not representative. I'm thinking, for example, about the United States now that they stop the right of abortion, where the majority actually of the United States of the population is for the abortion, but the Supreme Court has stopped us, somehow giving payments for the right to abortion. So, as I said, I think one has to evaluate from your personal perspective and never fully trust neither the legal actors nor the political actors. Exactly.
Never fully trust it.
Exactly. No, never fully trust them. No.
Okay. Maybe this is about your activity as a researcher.
Yes.
Do you have interest to research in Indonesian about system of law?
Yes. That's why we start this collaboration with the university here, Tanjung Pura University, because I had a very always interested in the Indonesian system because it's very particular, because it's called multi-layered. You know, there is multicultural, multi-ethnicity, religions. That's why it's multi-layered. It's not that there is a lot of culture. There is also a lot of religions. There are a lot of ethnic groups, a lot of social groups. So
that give impact to our law.
Yes, and it's interacting with each other. For a researcher, it's very interesting as a phenomenon actually. Moreover, there are different kind of laws. There is the customary law, religious law, the positive law. They interact in a very complex way, and that's for a researcher is very much particularly a researcher like me that I'm interested in the relationship between law and politics is very interesting actually as a case study as an object of studies.
Okay.
Maybe to live in it is much more difficult.
Yes.
But for a researcher is very interesting.
Interesting.
Yes.
In Indonesia, there is we can say this living law.
Yes, exactly. That's moreover that Indonesia is really a strong country. That is, of course, you have adopted something from the West, but there is a strong Indonesian identity also in the legal area. So it's very, as I said, it's very interesting.
Interesting.
Yes, very interesting.
And maybe the last, Mister, can you give advice or motivation to our young generation in Indonesia, so they have position to study about law?
What is good with law?
Yeah.
I think I realized with time I was lucky to choose law because, as I told you, I didn't make it as a choice. Because I like it. But what I realized with law, it has two big advantages if you study law, but really huge advantages. First one, I will say, is that you have your options open after that. When you study law, when you finish your studies, you have a lot of jobs. You know, there are some careers that if I want to study, let's say, to do engineer, I become an engineer.
Just for engineering.
Engineering. With law, you can do whatever you want afterwards, which is good. Because you know, when you choose a university, 18, 19 years old, you don't know what you are going to do. You need some time, and then I think law it gives you time to think a bit, because after 4 or 5 years, you know, okay, I would like to work in politics, or I would like to work in a big companies, or I would like to work in a public agency, or I would like to be a lawyer or a judge. You know, it gives you really your options open. You keep your options open. That's good with law. The second big advantage in studying law that you can change things. You can change with law. Yes, you can change things. Actually, I was speaking with a good friend of mine in Sweden. She's the most famous journalist in Sweden, and she told me that if she had to study again, she's a very progressive, very interesting, and as I say, one of, I would say, the best journalists that we have in Sweden. She said to me exactly what I was always thinking, that if she had to study again, she would study law, because with law you can change things. That's a good point with the law, that you can force people to do things. I mean, like she told me, like journalists, you print, then you hope they read you.
Yeah.
But with law, if you have good ideas, you can really implement them in society. So you can change things, regardless if you want to work in the private sector or public sector. It doesn't matter. But with law, really, you can change things. You can change things for the best. So that's I think that's the two things I would say should motivate young person to study law. First, that you are not force yourself in a career. When you are 18, you don't need to choose there. Okay, I will be this for the rest of my life. You have time, because law is an open profession. You give you. And the second, then, if you want, you can change things. Actually, you can make a difference if you want with the law. Yes.
Okay. Thank you, Mr. Professor Mauro.
Thank you very much.
About
Really.
your advice and motivation to us, to young generation. Para perennials, itulah tadi perbincangan kita dengan Prof. Mauro. Saya kira ada banyak hal yang disampaikan oleh Prof. Mauro berkenaan dengan bagaimana pengalaman hidup beliau ketika beliau studi di Sweden. Kemudian selanjutnya bagaimana dinamika perkuliahan di sana. Saya kira tidak terlalu jauh dengan Indonesia. Ternyata kalau saya tidak salah paham, di sana juga agak sedikit pasif mahasiswanya, sama dengan kita juga di sini. Tapi ada cara yang dilakukan oleh Mr. Mauro dengan cara melalui diskusi, memberikan arahan kepada mahasiswa untuk membahas berkenaan dengan dinamika kasus atau studi kasus dan lain sebagainya. Nah, kemudian selanjutnya berkenaan dengan juga apa yang disampaikan oleh Mr. Profesor Mauro, itu adalah berkenaan dengan posisi kita sebagai mahasiswa hukum. Ya, jangan pernah takut, jangan pernah ragu, karena orang yang kuliah di Fakultas Hukum itu sangat terbuka peluangnya untuk mendapatkan pekerjaan. Kalau kita berbicara tentang engineering atau orang yang kuliah di teknik, ya paling tidak begitu mereka selesai kuliah ya harus menjadi engineering, harus menjadi teknisi dan sebagainya. Tapi kalau kita di Fakultas Hukum, ya kuliahnya di Fakultas Hukum, kerjanya bisa di mana-mana, bisa di perusahaan, bisa menjadi lawyer, bisa menjadi legal konsultan dan lain sebagainya. Kemudian selanjutnya, yang paling penting yang perlu kita pahami dari Prof. Mauro itu adalah dengan kita paham hukum, kita bisa mengubah sesuatu. Ya, we can change things from law.
Yes, exactly. You have the possibility.
Dan itu adalah hal yang sangat penting, dan saya kira ini adalah bahagian yang sangat strategis yang dimiliki oleh kita sebagai orang-orang hukum, bisa merubah sesuatu, bahkan mungkin bisa berubah segalanya, bahkan kita bisa mengubah negara dengan adanya hukum. Saya kira itu perbincangan kita dengan hari ini dengan Mr. Professor Mauro. Thank you very much for you coming to here.
Thank you for having me here. It's an honor. It's been an honor.
I hope the next time we will meet again.
Absolutely.
And we will make a new conversation.
Absolutely. This is only the first step of a collaboration between our university, between Tanjungpura and Stockholm University. So.
Okay, thank you. Okay, very much. Oke, saya kira untuk pertemuan kita pada hari ini cukup sekian. Terima kasih. Wassalamualaikum warahmatullahi wabarakatuh dan salam perennial.